Judge, you serve in the General Sessions Court here in Nashville, which is a high-volume court, which hears both civil and criminal cases. And can you tell us how often people come into that court without lawyers, and give us a few examples of the most significant issues that are presented there in General Sessions?
Yeah, thank you, Matt, for inviting me. This is such an august group here. I'm really honored to be with it. Well, I want to recognize two of my colleagues who probably should be up here rather than I. Diane Turner and Bill Higgins are here, are excellent judges and handle pro se cases much better than I must say. We are, as our report says, it just came off the press, the court of first resort. That's what it says, right? The court. That means we see pro se cases day in and day out, all the time. We handle 228,723 cases a year. We do about 60,000 civil cases, including new cases and slow pays and whatever. Most of the people are not represented. It's a huge volume. This is the way I start my buck or Chief Justice. This is the way I start my pro se docket many times. And a lot of our cases that we try are all pro se. How many of you have seen Judge Judy? All the hands go up. And then I go, do I look like Judge Judy? And I do this. Turn around, and I get a laugh. Some people say yes. I say, this court doesn't operate like Judge Judy. And then I go through the process of how it operates and how a plaintiff presents a case, defendant asks questions, question mark is at the end of a question, what that means, and try to explain it on the front end. Judge Higgins, I can tell you, you've been doing this a lot longer than I. Most pro se litigants that I try and do this with do not listen. Because why? It's sort of like a lawyer. When you're in front of a judge, a lot of times you're rehearsing what you're going to do. A lot of these folks are not going to listen to what you say. Some will. So you might have to remind them as you go along. But I do try and do that. I wish I'd gone to the Judicial College. I've been way ahead. I didn't do it. And it sounds wonderful. So we see lots of them. Now, Buck, we have mediation 3 to 4 times a week in the courtroom. Free mediation. We offer it to everybody. And I encourage it, Claudia. I do. I build them up and explain what it does. Get very few takers. Why? Judge Judy. People are there to see a judge. They want to talk to a judge. You're the judge. Judge, I want you to make the decision. So for those that want to do it, it's a great option. We don't get as many as we'd like. But some people are itching for a fight, I'll be honest with you, and then we're going to have to deal with that. A lot of folks in our court are taking the day off of work, or most everybody is anyway, but they can't really miss another day of work if they don't want to. So we have to move cases fairly quickly. We do move cases fairly quickly, which means that we don't have the luxury in many cases of slowing down a case. Now, we will, in many cases, all of us will encourage people in complicated cases to get lawyers. And we do see complicated cases. I hate to say it, when I started practicing law in 1977, I did a lot for a long time before I became a judge. The jurisdictional limit, I think I'm right, was $3,000 in General Sessions Court. $3,000. So, that's $3,000. That's a lot of money. Now it's $25,000.
And in some cases, unlimited, right?
Yes, in some cases, I gave a $351,000 judgment. Me, a General Sessions, on a landlord-tenant issue. It was a commercial. Neither side was represented. Both were not originally from the United States. It was a mess, but that's what I gave. So small claims court is really, Judge Turner will agree, Judge Higgins will agree, in many cases isn't small claims anymore. This is money, not chump change. So it makes it difficult for us. in our capacity, I feel badly in many cases. I'm guessing. I'll be honest with you. I don't have a clue. I do the best I can because that's why they're there. So one thing that I have brought up, and Judge Rubin before me was a big advocate of this, is actually having a small claims court. Actually having a court where $5,000 is the limit, so that people understand when you start getting big money, maybe you ought to get a lawyer. And those people might, get a quick trial and understand that there's a difference between $5,000 and $25,000, even in a small claims court, because that's what we're called. One other issue that came up on the access to justice, I served on one of those committees a few years ago, was a collection docket. We get gazillions of collections. Now that business has changed. Collections are sold. It's no longer Bank of America versus, it is, but Bank of America is not involved in it. They've sold that down the line. There's very little documentation that goes with those, if any, just a sworn affidavit, which is difficult to deal with, and my suggestion would be to make people file actual documentation, because it's very difficult for us. Upper East Tennessee, in some courts, they're doing that, Buck. They've run into that problem in doing it. One other thing that I've got to admit, I've got to state very quickly, and then I'll be quiet, is I'm seeing, and I run a mental health court in addition to the other courts, and that's for people who committed crimes that are on probation that have serious and persistent mental illness. I've seen the number of people in my court in 10 years go from 50 to well over 200 at any time. And a lot of that is because we're criminalizing a civil matter, in my opinion, of hospitalization, judicial hospitalization, because the hospitals are full and people can't get in. And as a result, we're seeing a lot of these people fall back into the criminal system. And I think that's a big problem that we're seeing a lot of in General Sessions Court. And that's my 5 to 7 minutes. Thank you.
Thank you.